Someone make it make sense.
Probably a couple.
Hello, young lovers, wherever you are. Anyone recognize that song? Million scroll points. Welcome, guys. I'm so glad y'all are here. I will just say that as I kind of expected, it's really funny. A lot of people started getting ready to set up the streams for the jury selection today for like a way earlier, and I was like, no. I had a feeling it was going to be running behind. Sure enough, it's running way behind. So this actually works out. We're going to redirect from this into jury selection process. I imagine the struggle is real for Lori Vallow with that. Not jury instructions. If I said jury selection, I meant jury instructions. But we are going to pick up here after they had a break, and we are on cross exam. Couple quick announcements. Actually, I'll hold off on making announcements. Let's get into this, and I'll make some announcements here shortly.
I'm going to advise the defendant that anything that this witness read in another officer's report, he can't testify to whether those things are true or not, unless it fits into some exception to hearsay or non-hearsay.
Yes.
For you to establish that. So please don't ask any questions that he can't verify. He can testify to things that he observed, saw, or heard. But again, if you're referencing another report that another officer wrote, he won't be able to testify whether the contents of those reports are true or not, unless he has some sort of personal knowledge.
I understand, Your Honor.
All right, let's bring you can come back up, get ready to resume your cross. We'll bring the jury in.
All right. Can we all recognize that song? Let me do it this way. Hello, young lovers, wherever you are. Anybody know that song? It's funny. I've been getting ready for the next members only live stream, and one of the categories is musical trivia, like musical theater trivia. So, okay.
All right, thank you. The jury is now present. You may be seated. You can continue with your cross-examination of this witness.
Oh boy.
Detective Duncan, in all those text messages, we saw a lot of people. Did you interview our mother, Janice Cox?
I did not.
Did you read or watch her interview?
I have not.
Did you interview our sister, Summer Shiflett?
I did not.
Did you read or watch her interview?
No.
Did you interview our father, Barry Cox?
No.
Our father, our sister, our mother. Who's she referencing? Is she like including Alex? Weird.
Did you read or watch his interview?
No.
So the only source that you have for this investigation of the shooter in your case is through our brother Adam? Is that correct?
And all of the contacts mentioned through your iClouds.
Yeah, but you didn't ask anybody who was mentioned in there or who was speaking in there what they meant by any of those text messages.
Well, none of the people that you mentioned were present during this incident. So you're asking about the actual day of July 11th, if I asked them about that day or about the text messages?
About the text messages themselves. Like, did you ask my mother what she meant in that text message when she wrote it?
No.
Did you ask my sister what she meant in those text messages?
No.
Did you ask Melanie, my niece, what she meant in those text messages?
No.
Did you ask me what I...
Right. What do you think his life is like? For real. Like, do you, like, what the fuck? Why? Okay.
I meant in those text messages.
I couldn't.
Okay.
Ooh, wait, hold on. Let's hear that question again. That was spicy. Seeming?
No.
Did you ask my sister what she meant in those text messages?
No.
Did you ask Melanie, my niece, what she meant in those text messages?
No.
Did you ask me what I meant in those text messages?
I couldn't.
Okay.
Oh boy, did she ask for that one though. Look at his smile one more time. Lori, you fucking idiot, dude.
She meant in those text messages?
No.
Did you ask me what I meant in those text messages?
I couldn't.
Okay.
The smile is my favorite thing. That smile on his face right there. That's it, dude. Yes. Her stupid hairdo. I know, right? I think she does the troll hairdo when she has extra, when she's feeling extra snarky.
And through your investigation, you found out that, as you testified earlier, that Alex wouldn't text or call Adam back. Is that correct?
I'm not interpreting as far as he wouldn't do it. What I'm saying is I don't see it. So if there's a message there and there's a text, there's no indication that there was a call back or a text back.
So it looked like that he wasn't calling him or texting him back, even though he was getting calls and texts. Is that correct?
And then Adam also testified that he did not receive a call or a text back, which would be consistent with the records.
So the only person in our family, in our whole family, that you got information from was the estranged brother from our family who didn't know what was going on with everybody else.
I object to the form of the question. Argumentative.
Well, it's also compound. I'll sustain the objection.
Okay, so Adam, our estranged brother, is the only one that you got information from. Is that correct?
I object to the form of the question.
Listen to the change in the prosecutor's tone. She's so sick of objecting to Lori. Listen to her. Her voice is totally changed. It's like, Your Honor, I'm going to object to the like, she's like literally like, shoot me now. I would rather be dead than doing this. I don't blame her. Okay.
Who didn't know what was going on with everybody else.
I object to the form of the question. Argumentative.
Well, it's also compound. I'll sustain the objection.
Okay, so Adam, our estranged brother, is the only one that you got information from. Is that correct?
I object to the form of the question.
Sustained.
I wonder if she's switched over, she being the prosecutor, from more specific objections to objective form. You hear that more in civil, especially when it's depositions, because the form of the question can be a lot of different things. It's actually a vague objection. It's not really usually used in criminal trials. Now, here's the thing, right? So remember, and we've talked a lot about this with Karen Reed, and because they don't put their grounds on the record, which I hate. So when you say something like objection hearsay or objection argumentative or whatever the case may be, asked and answered, leading, speculation, there's a million, right? Two things are important here to note. One, it makes a thorough record, right, for appeal for both sides. Both sides should be doing this, right? Number two, it allows the other side to respond. So do you guys see why potentially that might be why she has changed? Maybe she's switching over, because that's twice now she's said object to form. And I'm wondering if it's because when she gives, like what has been happening, if she says hearsay or speculation or whatever, Lori, Your Honor, da-da-da-da-da, and starts just arguing to the court, right? But Lori doesn't know what to do if she says object to form. So I wonder if that's why that's happening. The reason that is done on actually in with civil litigation, especially in depositions, is because there is no judge present for those, right? They have a special master who they can call up or whatever when shit gets heated. But you just this is why depositions are so exciting to watch, because in civil depositions, here's what you've got. You've got a room full of defense attorneys on both sides with no babysitter, right? It's a bloodbath. It's a bloodbath, okay? They have no one there to stop them from killing each other, basically. And they're always videoed. So imagine that, right? Imagine like a trial, like these trials that we watch, but imagine if there was no judge and what would happen. I mean, really. So, so because of that, the reason they say object to form is it's preserving the record, so that then when they go back and play the deposition, again, this is common in civil cases, when they play the deposition at the trial, because a lot of civil trials, you'll watch a lot of depositions, then they can make the more specific objection, and it will cue them that there was something they needed to object to there in case they're zoning out. Essentially, this is basically what it is, right? They're objecting to form to preserve the record for themselves later on at trial. But the reason that they don't get more specific, right, is because then they'd all be fighting about it and there's nobody there to stop them, and then it would all erupt into chaos. So objective form is a really vague objection that doesn't really, it could mean a lot. Basically, all the other objections, with only a handful of exceptions, they all fall under the object to form umbrella, object to the form of the question. Like the vast majority of objections are in that category. So by saying object to form, it doesn't allow the other side any ability to argue, right? And that's the point for civil litigation in depositions, because then it would be just a shit show. Hopefully that makes sense. But that's why it's really funny. You don't hear it very often in criminal trials. So we are at Lori with eliciting 174 objections. Elaine, I know, right? It surely is. Do y'all remember when Elaine gave up? I loved that. That was one of my favorite moments. I'm sure I have it timestamped. It's like, this is the moment Elaine gave up. Like, it's right towards the end. It's like, a big sigh. I'm trying, Your Honor. It's like she's basically groveling. It's amazing. Anyway, all right.
So is this your normal protocol to just talk to one witness and not all the others?
No.
Why didn't you speak to any other member of my family?
I don't think I updated the
A lot of members of the family have been spoken to.
But you were not privy to any of that information as the case agent?
Well, I was privy to the interviews that were conducted by other detectives.
And you just testified to me that you didn't read or watch any of those interviews.
Word.
Is that correct?
I have been present during an interview or a phone call with Summer, and
Summer.
been present during a phone call in this process, but I have never interviewed them.
How many interviews has Summer had with the police departments?
Objection, speculation.
If you know,
I want to know.
If you know.
I don't know.
Damn it.
more than one or two?
I don't know.
Okay, but you knew of at least one.
The thing is, Summer's whole thing, right? So we were already talking about Summer before she came up in this trial. And it's really interesting because we only learned yesterday, right, guys? Towards kind of the end of his direct examination, we only learned yesterday that when Lori was hiding out and no one knew where the fuck she was at Summer's, and Summer was covering for her. And we talked about this because I remember Candace asking a good question, like, is Summer in the group, the culty group thing? And I said, no, but like clearly she has more information, right? And she's kind of stayed out of it, right? And what we've watched so far with Summer, again, because we were talking about her prior to this happening, we watched like her interview with Nate Eaton, but we were talking about how like there's not available, right? Publicly available yet. Her interviews with law enforcement are not available yet. Now, I'm sure they interviewed her. And that's why I was like, damn it, I want the answer to that question. Because I'm wondering if people are now going to put more effort into making those public, because people are going to be asking, I would think, a lot more questions about her involvement. And if anyone's the one to figure this out and find those and make them public, it'd be Nate Eaton, and I'm sure he's on it. I've not watched his courtroom insider from last night. I wouldn't be surprised if he mentions Summer at all. I would imagine he does. But anyway, so but what we are going to be doing on our next installment of what did Lori's friends know at the time, or whatever, what did Lori's friends say? We're going to be doing more Summer stuff, because we already had talked about this. We talked about wanting to revisit Summer's testimony. So I already had that saved on my playlist, but we haven't done that yet. So we're going to revisit Summer's testimony. I also have the jail calls between Summer and Lori and some other stuff with Summer, but we don't have her interviews yet. They've not come out. So I just wanted to touch on that there real quickly with Summer.
That Summer has had?
Correct.
Yes.
But you didn't ask her any of these questions or any of the questions about the text messages that you just talked about that were on the screen with Summer?
I said no.
Okay.
It's like asked and answered.
So as the case agent and a detective, do you form a suspicion and then stick to it and only investigate the things that lead you to that same conclusion?
No.
You had testified earlier about the story of Nephi, is that correct?
Yes.
And you said that you researched it, is
I
that
did.
correct? What research did you do?
Well, the very basic research. I Googled who is Nephi. What does Nephi stand for? I've also, through this process over the last 4 or 5 years, have asked other members of the church just a simple question: tell me about Nephi. And every single person I talk to tells me that same story that was told by Adam.
So are you aware that there's 15 books in the Book of Mormon?
I'm not.
Are you aware that 4 of those books are books of Nephi?
I'm not.
That there's Nephi 1, 1st Nephi, 2nd Nephi, 3rd Nephi, 4th Nephi?
No, I'm not.
Okay. That there's many stories of Nephi. Is that correct? Or do you don't know?
I don't know.
So the very first story is the story that,
I would object to testifying.
It sounds like that's the way it was going. So please just ask questions.
so you did not read the Book of Mormon?
No.
You did not read 1st Nephi?
No.
You just asked people. That was your research?
I asked members of that particular church, and I also did an internet search. Yes.
So you did an internet search. And it gave you all the stories of Nephi?
That's the story that came up.
So how long did you do that research for?
I couldn't tell you.
So in your research, did you discover that there's about 25 stories of Nephi in that Book of Mormon?
I didn't see that, no.
And that there's 4 different prophets that are called Nephi in the Book of Mormon?
I'm going to object as to testifying, and the detective has already indicated, so asked and answered.
I'll overrule the objection. He can ask if he knows that or not.
What was the question? Sorry.
I'm sorry, I can't remember. Can the court reporter? tell
There's
me?
4 different people referred to as Nephi.
Yeah, 4 different prophets in the Book of Mormon that are Nephi. Are you aware of that?
No.
Okay. So isn't it true that you really have no idea what I was referring to when I referenced Nephi in my text message?
I can only go off of what I see. I can't tell you what you're thinking or what you're trying to relay there, but based on my knowledge and based on talking to people about who is Nephi, that is a story that came up consistently.
You relayed to the jury that it was in order to kill. You relayed to the jury.
I said that the story was the same story and similar to Adam told.
Okay, and you said it earlier that that was in order to kill. That I referenced Nephi. I will be like Nephi and you will be like Nephi. To the jury here today.
Ask a question. That's a statement, not a question.
Do you have knowledge that my text message meant that at all?
No.
Are you aware through all of your investigation of this case that my brother was a stand-up comedian, Alex?
I heard that, yes.
Oh,
And everything
now
was a
that was
joke?
actually, that question was actually, I need to update my ticker. That actually was an okay question for her. I mean, is it going to help? I don't think so. I doubt it. But that was
Knowledge that my text message meant that at all?
No.
right, that he can't actually say what she meant by the Nephi thing. Okay, it's really a fact for the jury to decide, right? Based on everything. That's really in the province of the jury. So let me update my ticker. Candace, we're going to get some more information as to her plans regarding testifying here very shortly. So also there's a lot of asked and answered. The state's not objecting all that they could, but that was also really funny when the judge answered that question. I've seen that very rarely when the attorney doesn't remember something and they ask the court reporter. Generally, the judge is not going to jog their memory. I've only seen it a handful of times. I think it's because it's really in a situation where the judge is just trying to move this thing along, because sometimes with the court reporter, it can take a hot minute for them to find it. And depending on what type of system they're using, if there's shorthand, I've seen it where sometimes they ask them to read something back and it takes like a solid minute or whatever for the court reporter to be able to do that. So anyway, all right, let's carry on.
Are you aware through all of your investigation of this case that my brother was a stand-up comedian, Alex?
I heard that, yes.
And that everything is a joke to Alex?
Care anymore.
I can't speak for that.
So when you're interpreting all these text messages and making all these assumptions, half of them could be jokes and you would not know that?
Objection, speculation.
Sustained.
And again, that's really going to be in the province of the jury for them. Just like with every case, right? Whether it be Karen Reed and the text messages that she had that were shown at trial with Higgins and with John O'Keefe and whatever, or like Shanna Gardner's case, right, where you had the Kimmy text messages. The context is going to help the jury determine, because no one can know what someone's really thinking, obviously, right? But just like the people that are texting, right? How is it that the people that are actually the ones texting are usually able to figure out if someone's, for example, being sarcastic or not? Now, not always, right? But how is it that oftentimes you understand what the other person means, even if it's text message? Well, it's because you have the context, right? So it's a similar, you're not going to call the person up and be like, with every text message, hey, what exactly did you mean? Can you say it with the tone that you were thinking in your head when you sent the text? No. So the context. So just like with all these other cases, the jury's going to have the context to try to interpret whether or not Alex was joking. Anyway, I need to update my ticker.
Were you speculating when you read my text messages?
I think I'm just reading your text messages. I don't think I was drawing any inference from them. I was just simply reading them.
Well, today you were explaining them to the jury. Is that true?
Those were read. There was no explanation as to what it meant.
As the case agent, what is your communication with the other investigators in this case?
What do you mean by other investigators?
Oh, boy.
So who is on your team? Who is working for you on this case right now?
I'm the only person working on the case right now. Back in the, when we were investigating it, would have been myself and Detective Coons. And then periodically we'd have Detective Werther do some work for us if we needed it.
And then do you guys communicate through emails or calls or text messages, or how does that work?
Well, unfortunately, we're cramped in a small little area, so we have the ability to just talk to each other.
So no reports are really made of that communication. You're just talking?
Correct.
And being a detective, is your job basically to be an investigator and search out facts concerning what happened?
Yes,
Do you feel like you've done that in this case?
I do.
So by not testing any of those things, you feel like you've done everything you could possibly
Yeah.
do to tell the jury and to tell us what happened that day on July 11th, even though you weren't present?
Correct.
You're confident in that?
I'm confident.
Wow.
Did you have to meet with Detective Moffett to review the case when you made this transfer?
No.
So he didn't give you any heads up on what was happening?
Well, before he left, he just dropped the case notebook on my desk and then went on his way.
Can you guys picture, look at the way he, listen to that. Picture how that went. Listen to this. Wow. Your problem now. That's how I interpret that.
Give you any heads up on what was happening?
Well, before he left, he just dropped the case notebook on my desk and then went on his way. We have
So-
had conversations before then and since, but nothing in detail.
So you didn't say what's been tested or what hasn't been tested
No, that's for me to go back through and look at.
through reports?
Correct.
Okay. So did you think it was important to maybe luminol the bat?
Once again, there was no visual
my
blood
God.
present on the bat, and we decided that we were not going to do that particular process.
So can't blood be invisible and still be on the bat if you luminol it?
I guess if it's cleaned off, it would still maybe show some proteins, but that was something we decided not to do. We fingerprinted it to show, because there was indication that Charles had grabbed it from Tylee. So we did our best evidence to try to grab that location where it would have been grabbed, but that's what we did.
Wouldn't that be important to your investigation?
Objection as to wouldn't what?
Yeah, please.
Wouldn't luminoling the bat be important to this investigation, this particular investigation?
I don't believe it would.
What about luminoling the gun? Was that done?
Once again, there's no visible, and we were under the impression that it happened 5 minutes before we got there, and there's no visible presence of blood on the bat.
Well, you went around the whole entire house looking for blood, is that correct?
Yes,
And you had the gun in your possession,
yes,
and you're in a police station.
I was at your house.
I'm saying you have access as the case agent to have any of these things tested, is that not right?
Yes,
So why didn't you test them?
because I did not think that luminol was needed to be tested because there was no visual blood.
So wouldn't you like to know that for sure?
I guess you're
One of the other good points she can make.
we make choices.
Honestly, this is a way more important point than the Nephi thing. And we see this with other cases. What do I all say? Why not test it anyway? Why not test it anyway? There's no reason not to. Normally this would be a defense attorney. They know they're going to get asked this, right? Whether or not there was blood on the bat really matters here. If anything matters, right? If anything literally matters at all for her, for her theory of the case, blood on the bat is really important here. And they didn't see any, but they didn't do any further testing for the blood in case that it just was, not visible with the naked eye. They should have done it, regardless of anything else. They should have been done. Like, why not,
I guess we make choices and we make decisions through this process based on the facts that we have, the facts that are presented to us. And based on the facts presented to us and what we saw and what we had, I did not feel that was necessary.
That didn't really answer the question, though, to be
You have
honest.
charged me with a crime. Is that
Oh,
correct?
boy.
I have not, no.
You have helped them charge me with a crime. Is that correct? The state of Arizona?
I conducted an investigation and I sent it forward, yes.
And you did not feel it was necessary to test any of these things?
Objection.
As the case
asked
agent.
and Answered like 4 times.
Sustained.
I need these things vague.
What logical reason do you have as an investigator to not investigate all of these things that were available
Well,
to
thank
you for the
all-
past 5 years.
Objection
Your Honor,
vague
I'm again going to object, asked and answered.
and vague.
If there's a specific thing that
That's
hasn't been asked,
That's a really very broad question. I'll
Right. Thank
sustain the
you.
objection.
That's, dude. So basically what happened there was the judge liked my objection better than the state's. I mean, it's vague.
That's all I have, Your Honor.
Oh, fuck.
Redirect.
He's sitting down at 184 objections. Wow. Look at that. Guys, watch this. Watch this. Watch their exchange here. Wow. Oh, man. These two women do not like each other. Don't blame them.
That's all I have, Your Honor.
Redirect.
Watch that. Lori gave her a look. Lori gave her the side eye.
Detective, I'm going to
You.
start by just talking to you a little bit about luminol.
Okay.
Is luminol a process used where you believe a scene has been cleaned up, like somebody actually attempted to remove blood from the scene, and so it's been diluted?
Correct. And it would show the remaining proteins left. Yes.
And so luminol is used when there is no visible blood because the scene's cleaned.
Correct.
And so in this case, you were under the impression that this homicide had occurred 5 minutes before police arrived?
Yes.
So you would not be expecting a cleaned up scene.
Correct.
But you did look to see if you saw visible blood.
We did. Yes.
And by visible blood, you're talking about drops of blood that might be there,
Correct.
swipes of blood that might be there,
Correct.
hairs from someone's head that might be stuck in the bat.
Yes.
And did you see any of that?
No, we did not.
Now, after this, did you learn that there was actually this 47-minute process?
We did.
So when you're processing the scene that day, you were not aware yet of how extensive this timeline was incorrect.
Correct.
In fact, we heard from Detective Werther that it was sort of the next day as he started going through the phone from Charles.
Yes.
And the day after that, as he's going to get videos from Burger King and Walgreens, that you're learning that this timeline is very wrong.
Correct.
I want to talk about the data that you have reviewed in this case. When you talk about what was reviewed, whether by you, well, let's just say by you. In these iCloud accounts, are you talking terabytes of data?
Yes. Each iCloud account can have terabytes of data, and you have to, and it's tedious because you can only look at one at a time. We can only look at one particular iCloud at a time and go through that, make notes. Then you'd have to shut down, open up another, and look through one iCloud at a time, and then try to, with your notes, to match these together. So it's a very labor-intensive process.
And as you're looking through this, are you then learning more things that then makes you have to go back to the other iCloud account to try to see what you could find in that?
Absolutely.
So when we come in here with just a few documents and a few things, would it be fair to say that's just a grain of what you've gone through?
Absolutely.
So on July 11th of 2019, when you arrive at this scene, you think this homicide just occurred, did you understand at that time the relevance of cell phone or iCloud data?
No, what's something that happened, what sounded like it was a rather quick incident. It just happened 5 minutes ago. I wouldn't think of the necessity for cell phone data, like to show planning or anything like that, or show conversations over the weeks and months. Sometimes we get cases where, oh, this person's had beef with me forever. Obviously, I am going to want to take that phone and go look through that. But in this case, we just had something reported to us that happened just 5 minutes and very limited information, as it was almost an impromptu attack. We had no information at the time that this is something that had weeks, if not months, of planning.
On July 11th of 2019, did you start to see inconsistencies between the statements that were being given, the timeline, and the physical evidence at the scene? Did you start to see some inconsistencies?
Yes.
For instance, you were provided with a self-defense theory. Did you see inconsistencies between that statement and what you're seeing at the scene?
Yes.
And that's where we're talking about the location of the bullet wounds to Charles, the bullet strike under his left shoulder, and the bullet being by his left shoulder for one of those shots.
Correct.
But again, you're still not aware of the background of these individuals.
Correct.
As you began learning more information about the interaction between Charles and Lori Vallow and learned about the individuals, were you then able to obtain information to allow you to write search warrants to even obtain phone records and iCloud accounts.
Yes,
So that's not just something you can be like, hey, I just want that, so I'm just going to ask iCloud for it, and I'll just hand that right over.
correct. You have to have probable cause in order to get that.
You were asked about DNA and blood. And I think you had said something about it. Is DNA only found in blood?
No,
So saliva can have it,
correct,
sweat.
correct.
So when you're asked about blood on the bat, that isn't the only form of DNA that would be left on there potentially.
Correct.
So if you had information that the bat belonged to Tylee, no matter what, you would expect to find her DNA on it.
I would,
Not, regardless of whether she ever bled on it, right?
correct.
Was blood something different you were looking for, though?
It was,
And was that due to the fact that there's this allegation that Alex Cox was hit in the head with the bat?
yes,
And so we have the bat here. You looked at it yourself, did not see visible blood,
it did not,
and we have someone else who processed it and didn't see visible blood on it.
correct.
Even on the edge top of it, do you see any sort of damage to that plastic around the tip of it?
I do not,
If you had processed that bat for DNA and you found Tylee's DNA on that, would you have told you that she put it on there on July 11th? Did they ticky mark that for you?
it would not,
We'd just say it was on there, right?
correct.
Are you able to time that in any way?
No,
When the medical examiner comes out, the medical examiner's office comes out to the scene to collect the body. Body doesn't leave in an ambulance, right?
no, it does not.
They have a van.
Yes,
And
Yeah, that was a dumb question.
Does the
from Lori.
doctor
She was like, did
confirm
you go in an ambulance? Like, how, what?
the autopsy come out there with you guys and
no, he
check out
does,
the scene?
he does not.
So when a medical examiner testifies as to a wound being shored, but not knowing what it was against, he's not out at the scene looking at the body, right?
Correct,
He's not out at the scene looking at the projectile defect or on the ground underneath Charles's left shoulder.
correct,
He's just saying that wound is shored. Whatever he was against is what it was.
correct.
But you were at the scene
I was,
and you saw the shoulder in line with that defect on that ground or on that floor that you collected.
correct.
Now, did you ever have any information that Janice Cox or Barry Cox or Summer Shiflett were present at 5531 South, Four Peaks on July 11th?
We did not,
In fact, it appeared that Summer was actually going out of town, so she wasn't going to be around on the 11th.
correct.
Now, you had mentioned that you were present when Summer and Janice were interviewed. Was that when the state interviewed them when they were listed as witnesses potentially for the defendant?
That is correct.
And in fact, did you recall Summer being asked about her offering her house to the defendant to stay at?
I do,
What we had seen in the text
Mhm.
message?
correct.
No.
Was there anything about that statement that appeared to be untrue based upon your hearing or participating in that?
There's nothing.
In these text messages and iCloud account records, start with Ned. When you first started seeing those, were you understanding the full story of where that came about?
No,
Did you then have to look to other people who, like Serena Sharp or Christina Atwood or others who were aware of who Ned was,
correct.
what Ned was?
Yes,
In terms of Nephi, you said that we heard from Adam when he's asked about Nephi, what that meant to him.
Correct.
He provided us with a story of Nephi and Laban, right?
correct.
You
Laban.
said you Googled this like many of us do, right? Start out there.
Right.
And then you actually spoke to other members of the Church of Jesus Christ of Latter-day Saints.
I did.
Was that to make sure that you weren't missing something?
It was to make sure that there wasn't another story that might be out there that he's known for. And so, like I said, I would just randomly ask people that. And every single time I would ask
I
that,
just have
that
one
was the story that was told to me.
So others who were members of that church spoke the same way that Adam did.
Yes,
You're asked a lot about sort of processing of the scene and processing of the items of evidence. Was this case, let me ask you this, was the physical scene itself inconsistent with what was initially told?
Yes.
And did it require additional research into all of these different iClouds, cell phones, cell tower records to clarify what happened?
Yes, as the weeks and months went on, additional information was learned that basically required those accounts to better understand what took place.
And was that what then you spent months going through?
Right.
That is weird. I have feelings about the name Ned. I don't know. It's an interesting name. Candace, what are your thoughts? I mean, some people have exes that they're still friendly with. I'm going to hold my thoughts on the name Ned before I hear what you think of what your relationship is with your ex.
And ultimately, after all of that, is when you eventually presented that case or turned it in to be reviewed.
Yes, I did.
I have no other questions, Your Honor.
Okay.
All right, are there any questions for this witness from any member of the jury? I see at least one.
Okay. Jury questions? Boy.
That'd be,
Exhibit.
well, I think we're going to need that exhibit. Go ahead. We'll see if he knows, though. Regarding the pictures on Alex's phone sent to Lori, what was the time on the top left corner of the pictures? Do you recall?
I don't know for certain. That was afternoon.
Would it refresh your memory to look at?
They have to get the picture.
All right, so that's been admitted into evidence.
By the way, I'm still working on timestamps, of course, but I have this part timestamped from earlier in the day, from yesterday, when they show this. And I timestamped it for this reason, because the jury asked a question about this. This jury is paying attention because this is a great question that I didn't even think of. Now, having said that, we were in the thick of our conversation, I believe, about anesthesia and all that. However, this is a great jury question. Listen to this, guys. This juror, wow.
That was afternoon.
Would it refresh your memory to look at
Yes.
that photo?
Yeah.
Admitted into evidence.
Okay.
The time is 2:13.
And the next question is the countertop in that picture, do you recognize that as whether or not that's the same countertop at the Santana, or the Four Peaks address?
What a question.
That is not the same as the Four Peaks address, no.
Okay.
And it's going to show it. So the question, what a question. What a question. Is this counter the same? I mean, wow. Somebody could be a detective. Like, is this counter the same counter from the Twin Peaks home address? And it's not. Whose counter is it? We don't know, but interesting. I would maybe assume this is Alex's counter at his house, but if that's the case, it means he took possession also of Charles's phone. We know Lori had it earlier. Did they trade off maybe?
Before I go for follow-up to the parties, are there any other juror questions? I don't see any. Follow-up from the defense based on that juror question?
No more questions, Your Honor.
All right, from the state?
Just that in that exhibit, the photo, of the phone, do we see both sort of Tuesday, 9:08, when these messages occurred, when, as well as sort of what time the phone is showing?
Yeah, I think the most telling thing is this is a communication between Adam and Charles. Clearly, the only phone that they had would have been Charles' phone, not Adam's.
And this conversation matches what you saw extracted from Charles's phone later between he and Adam on the 9th of July.
Correct.
Other questions from Your Honor?
All right, you can step down, sir.
Okay. All right. So, moment of truth, guys, moment of truth. What's going to happen? This, I will just say, the end of this day yesterday reminded me so much of the Zachary Hughes case in South
This time
Carolina.
the state has no further witnesses. The state will rest.
So we were expecting 3 witnesses. So 2 after this dude that just finished, they're resting. So that was shocker number 1. They're resting. What?
All right, the state has rested its case, which means the state's portion of the evidence is done. I'm going to excuse the jury for a few minutes before you go home for the evening. Let me just do a consultation with the parties about tomorrow's schedule, and I'll let you know what time to report back. It should
Okay.
just be a couple minutes. So please remember the admonition. We'll let you know. So
now it's, what are you going to do, Lori? Are you going to have a case in chief?
do you plan on presenting evidence?
Remember, she's made it seem this whole time like she's going to. My investigator needs the cell phones and the computer, and we're going to do our own Celebrite, and my list of witnesses that I'm da-da-da-da. What's she going to do?
Can I confer with my
Yeah, go
team
ahead.
for a minute?
Also, I just want to remind everybody that even if she does none of that, her taking the stand could be her case in chief. She could take the stand and that could be it. So. They're conferring still.
20 motion first.
Hold on.
Your Honor, I'd like to address a Rule 20 motion first.
So she's going to keep us in suspense. What this is you guys are well familiar. This is a motion for a directed verdict. We have it in every case. Lori has to argue a motion for a directed verdict. Okay.
Go ahead.
Okay. The state,
Oh my God, the way he says go ahead.
Your Honor, I'd like to address a Rule 20 motion first.
Go ahead.
Okay. The state has failed to show substantial evidence for count 1,
we
conspiracy to commit first-degree premeditated murder. The state has provided no evidence that I agreed with another person that any one of us would engage in certain conduct that I intended to promote or assist in this premeditated murder. Crime premeditated murder requires the state to establish a person caused the death of another with premeditation. The lack of evidence to show any evidence of a conspiracy to commit murder. There was no plan to murder Charles. No evidence has showed that, in fact, evidence suggested self-defense on the part of Alex. So I would like to put that on the record.
All right. State, want to put a response on the record?
Yes, Your Honor. Looking at the evidence in the light most favorable to the state, there's sufficient evidence based upon
Okay.
everything
So
from
this
the
is-
iCloud
so
messages.
remember, when they do a motion for a directed verdict, this is crucial to remember. At this point, right, they have to, the judge has to look at it in the light most favorable to the state when they do a motion for a directed verdict. So that's why they are so vast majority of the time they're denied.
From between Alex, the defendant, and others leading up to July 11th of 2019, that Alex Cox was invited over by this defendant, knowing that they were going to be having an intervention and knowing when Charles would be there and bringing a handgun over with him. The timelines on July 11th of the killing of Charles.
I'm going to back it up because she's basically stating what the summary of what evidence she thinks they have against Lori. But also I wanted to mention for civil cases, right, where you have a plaintiff and a defendant, and they're countersuing, which is very common. Then you can have it for both sides. So it's done at the end of one side resting. So after if the plaintiff, they have their case in chief, at the end of their case, then the defendant in a civil case again could make a, could and does make a motion for directed verdict, and then vice versa, right? So then when you have a defendant and also maybe if there's a countersuit, then they're the plaintiff, right? Then when they go, then the first plaintiff can make a motion for a directed verdict. So I just wanted to point it out because there's a distinction here. In other words, the state in a criminal trial cannot make a motion for a directed verdict against the defense. But I just wanted to point out, again, in a civil case, there's things that are different because you have two sides. One side's not the government. So you will see that from both parties in a civil case.
All right. State, want to put a response on the record?
Yes, Your Honor. Looking at the evidence in the light most favorable to the state, there's sufficient evidence based upon everything from the iCloud messages from between Alex, the defendant, and others leading up to July 11th of 2019.
iCloud
That Alex
messages?
Cox was invited over by this defendant, knowing that they were going to be having an intervention and knowing when Charles would be there and bringing a handgun over with him. The timelines on July 11th of the killing of Charles Vallow and the fact that the number of shots and the physical evidence at the scene, the statements by the defendant to Detective Clan that she took Charles Vallow's phone and would not give it back to him, the motive for money, and especially the defendant's motive for having an affair with Chad Daybell. All of those looking at together in the light most favorable to the state, the defendant or the jury could find the defendant guilty of conspiracy to commit first-degree murder.
I'm going to summarize those real quick. I just made a little list. So what she said was, in summary, what she finds to be the evidence that the state has against Lori to prove the crimes as charged. The iCloud account showing that Alex was planning on coming over there ahead of time at the same time that Charles was going to be there. That was number one. Number two, Alex brought a gun with him. That was number two. Like I said, okay. Number three, the timeline on the day of the shooting. Number four, the physical evidence at the scene. Number five, the defendant's statements that she made. Number six, the motive for money. And number seven, the motive because of the affair with Chad. Was that it? 7 of them? I think it was 7. Anyway, that's the summary. I'll read it one more time, and this time to make sure I get my counting correctly. So number one was the iCloud account showing the communications that Alex was planning ahead of time, so premeditation, to be there at the same time as Charles. Number two, that he was going to be bringing a gun. Number three, the timeline on the day of the murder being all fucked up. Number four, the physical evidence at the scene. Number five, Lori's own statements to Detective Duncan. Number six, the motive for money. And number seven, the motive because of the affair with Chad. There you go.
Last word. Do you want to add anything?
No, Your Honor.
All right. The standard is whether or not a reasonable juror whether or not there's substantial evidence for a reasonable juror to find the defendant guilty. The court does find that there is substantial evidence that a reasonable juror could find the defendant guilty. The court will further add that the jurors are the ones who judge the credibility of the witnesses. Yep. And it's ordered denying the Rule 20 motion.
That's probably why.
Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
Now, here is the question we were wanting an answer to, but she did her motion for directed verdict first. That's not uncommon. Now the question, we're back to this question, is she going to put on case G?
No, Your Honor, the defense will rest.
All right. If that's the case, I'm going to tell.
I died. I was like, you've got to be. Again, remember, reminds me so much of Zachary Hughes. We were expecting 2 more witnesses after Detective What's-His-Face, Duncan. And instead, we have the state and the defense resting. What is happening? I know, right? I literally, y'all.
The jury. How long does the state anticipate its closing argument being?
Annie, it's actually clear and convincing. Preponderance is, I don't even think it's ever even used in criminal cases. I guess preponderance of the evidence would be like a search warrant, right? Or like probable cause. But it's easy to get the words confused. Clear and preponderance is the same as greater weight. So that's 50% plus 50% plus a grain of sand. I know it sounds like that when he's the light most favorable to the state, but the standard, to my knowledge, is 85%. My estimation is 85%. You could call it 75%, but it's clear and convincing. I feel like that's more of an 85% standard, but you could split the baby and go with 75% because it's 50.01% versus 100% or 99.999%, right? Being beyond a reasonable doubt. So, right. Well, no spoilers now.
I would assume probably over an hour.
How about the defense?
Less than that.
Can we do the closings at 1 p.m.? We can formalize all the jury instructions at 10:30. Is that enough time?
The state would request that we do them Monday to ensure that the state would request we do closings Monday to ensure that we don't finish with a rebuttal closing on Monday.
Well, I'm willing to go in the morning if we want to start in the morning at 11 and do jury instructions at 10:15 or something like that. Does that work?
Again, I'm asking for Monday, but if the court does not allow that, then we'll go whenever the court says tomorrow.
What I don't really understand is why she thinks they wouldn't have time to finish the rebuttal closing. I wonder if she's thinking jury instructions will take a long time. They did get started really late, which I expected, and I was anticipating that. It makes sense to not want to have them broken up over the holiday weekend, but I don't know why it seems like you should be able to get the jury instructions knocked out in the morning, and then, I would imagine what you could do is then after lunch, right? Charge the jury with the jury. Well, I don't know when he's going to do that because sometimes, anyway, so let me just table that thought. I prefer to have jury instructions read to the jury before closing arguments, but everyone does it differently. But anyway, either way, you could still finish, I would think, closing arguments after lunch because Lori said only half an hour. She said an hour. Rebuttal close would then be probably half an hour. So that's only 2 hours. Add into 15 minutes for slogging around, 2 hours and 15 minutes after lunch, right? They get back from lunch at like 1:30. That's plenty of time. so it makes me wonder if she's worried more about the deliberation process because it's a holiday weekend, and I don't know what their dealio is there. Like if they, because normally, you know, some courts will allow them to deliberate over the weekend. It just depends on the court, but because it's a holiday, might be different. And I wonder if what she's concerned about is like they start deliberating, but then they only have like 10 minutes, and then it's like they have to come back on Monday, right? So anyway, those are just some of my thoughts. Like my initial thing was like, it just seems like maybe she's more worried about breaking up the deliberation process than breaking up the closing arguments, because I don't see why they wouldn't have enough time. But anyway.
Do you want to weigh in?
Well, just that we haven't had time to go over the jury instructions. I don't get back to the jail until like 5:30 or 6 o'clock. So
You agree then that Monday's better?
I would agree.
All right, we'll tell the jury to report at 10:30 a.m. on Monday. They don't have to come in tomorrow.
Judge, could we have the defendant rest in front of the jury before they leave today?
Are you prepared to rest today? If you rest, that means you can't change your mind about testifying.
Can we do it on Monday?
We can do that on Monday, but if you change your mind, I need to know in advance because it's going to change the jury instructions and it's going to change the schedule.
Absolutely, I will let you know.
All right. Tell the jury they don't need to report on tomorrow, that they need to report Monday at 10:30 a.m. Okay. So let's meet tomorrow, though, to finalize the jury instructions. Why don't we just do that at, what's tomorrow, Thursday?
10:30?
We'll just do it at 10:30. That'll be enough time for you to read those tonight.
Yeah, if I could have time to meet with my advisory council before that, that would be great.
I can put it on the
Be
calendar.
brought in.
I can put it on the calendar for 10, and I think you, well,
11?
I can put it on the calendar for 10 so you can meet with them back here, and then we'll meet at about 10:45. We'll have come in the courtroom and finalize the jury instructions. All right? If I did give a copy to your advisory councils as well, or at least one
Let
copy.
me back it up real quick.
Meet with them back here, and then we'll meet at about 10:45.
So 10:45. So I was thinking, so 10:45 plus 3 hours would be 1:45. With the 15-minute delay would be 2:15. Yeah, they were definitely not on at 2:15. I just remember thinking it was hella late. But I assumed Lori was going to need more time with her team. I assumed that 45 minutes would not be enough time. But it's hard to see. I thought all that. I did all that math in my head, and then it's like the court feeds will start early, so I don't know. It might have felt.
We'll have come in the courtroom and finalize the jury instructions. Right. If I did give a copy to your advisory councils as well, or at least one copy there. So if the advisory councils and or the state review that tonight and see something additional or correction that needs to be made, go ahead and give me a heads up so I can be prepared to talk about it tomorrow as well. So, all right, we'll see everyone in court at 10:45, but we'll put it on the calendar for 10 a.m. so that the defendant can meet with her advisory councils at 10 a.m. All right, thank you.
All right, and with that, we're going to pop right on over. So let me roll the outro. This should redirect you guys into the next stream, which is the jury instructions. So, all right, see y'all here in just a sec.